Good evening and welcome to the July 11th, 2019 Civilian Police Oversight Agency Board meeting. We're going to start with the Pledge of Allegiance. Ms. St. John.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. The mission for the Civilian Police Oversight Agency Board is advancing constitutional policing and accountability for APD in the Albuquerque community. Can we get an approval of the agenda?
Motion to approve.
I second.
All in favor?
Aye.
Aye. Are there any public comment this evening? No. Okay. Moving on. Can we get a motion to approve the minutes from last meeting?
I move to approve the minutes.
I second the motion.
All in favor?
Aye.
Aye.
Wonderful. Reports from city staff, beginning with APD.
Good evening, Chair Galloway and members of the board. I'm Commander Mark Velarde with the Albuquerque Police Department Internal Affairs Professional Standards Division. For the month of June, we responded to 40,871 calls for service, which was a decrease of 1,400 from the month of May. Also during the month, we completed 12 internal affairs investigations. Discipline ranged from 8-hour suspension, 4 letters of reprimand, on-duty conduct, verbal reprimands, 8-hour suspension, 16-hour suspension, 48-hour suspensions, letters of reprimands. We had 19 ERS distributions during the month. We had 15 pending IA cases and 14 opened internal affairs cases.
Does anybody have any questions?
Thank you very much.
Wonderful, thank you. City Council, Mr. Moya, hi. Oh, forgive me. Oh, forgive me.
Good evening. Thank you, guys. My name is Tony Fincher, and I'm currently one of the lieutenants within the Internal Affairs Force Division. So in reference to use of force, the Foothills had 1 serious use of force, 1 show of force, 12 regular uses of force, which is actually up from the month of May. Northeast, we're looking at 2 serious use of force, 1 show of force, 8 use of force, for a grand total of 12, which is actually down 2 from last month. Northwest, we had 2 shows of force, 1 use of force, for a total of 3, which is down 7 from last month. Southeast, we're looking at 4 serious uses of force, 4 shows of force, and 9 uses of force, for a grand total of 17, which is actually down from 2 from last month. Southwest was 1 serious use of force and 8 uses of force, for a total of 9, which is actually up 2 from last month. The Valley, we're looking at 2 shows of force and 10 regular uses of force, for a total of 12, which is down 2. So I believe, and I left the paper back there, but I believe for the month of May, the total was 71, and ultimately this month is a total of 67.
I would like you to clarify, because this is recorded, of course.
Yes, ma'am.
So I think for the public, sorry, I'm losing my voice too. For the public out there, the regular use of force, the show of force, and serious use of force, could you explain what the difference is between those things briefly?
Yes, ma'am. So right now, what we have categorized as serious uses of force are going to be something similar to like officer-involved shooting, canine apprehensions, uses of force that end up in hospitalization or loss of consciousness. And so those are serious uses of force that have potential for great bodily harm and or injury. So that's where that category lies into. With the regular use of force, you're looking at, within policy, our low-level control tactics and our intermediate uses of force, such as like an ECW deployment that is no more than 3, which would
A
result.
what deployment?
ECW, which is electronic control
Okay,
weapon.
I'm sorry. Go ahead.
Taser, most commonly known
Yeah.
as. So that's where it differentiates between a regular use of force and then what is categorized as a serious use of force. Now, some of this will change moving forward, just because with our new policies and our new training, we're going to be going into our tiers, our levels of force. We're currently at Tier 2, are getting ready to start Tier 2 of the training for the new levels, which will be Level 1, Level 2, and Level 3. And so these numbers can be, or will be different moving forward in the future, because with that new categorization, we're taking on other uses of force, such as chemical munition deployments by tactical, which hadn't been categorized before as uses of force. So some of it will change moving forward.
Did you say what show of force was? Would that be like pulling a gun
So
instead of?
a show of force, what it is ultimately drawing the tool or weapon from your belt and giving verbal commands at the same time, ultimately to compel or elicit compliance from an individual.
I just think it's helpful to remind the public what we're talking about.
Yeah,
So thank you
absolutely.
very much. I
Yes, ma'am.
appreciate it.
Any other questions?
Will you be joining us every month?
Maybe not necessarily me, but somebody from our division and our team will. So it'll either be myself, Lieutenant Ken Johnston, Lieutenant Juan Cabrera, or Commander Rob Middleton.
Okay, and can we have the report that you just gave, something similar, the way the IA presents their report, so we get a paper copy of that, we can see it in front of us?
Yeah, absolutely.
That would be awesome,
Yes,
thank
ma'am.
you. Anybody else? Okay.
Thank you, guys. Have a
Thank
wonderful
you.
night.
Right. Now, Mr. Moya, thank you.
Madam Chair, board members, as everyone is aware, council approved the appointments of Ms. Armijo Pruitt and Mr. Olivas at their last meeting in June. And I'd like to just thank them and welcome them and thank them for their willingness to serve on this board. We still have one vacancy to fill. Our office will be reviewing some recent received applications this month. And we'll have a recommendation to send to the outreach committee by the beginning of August. And with that, we'll send them an invitation for that prospective member to attend the August CPOA board meeting. And if all goes well, then we can introduce that appointment at the second meeting in August, our second council meeting in August. At the upcoming August 3rd council meeting, the 2017 CPOA annual report will be on the agenda for formal receipt. And also our office has received the board's updated policies and procedures. And we will have an OC, it's a other communication ready for introduction at the August 3rd council meeting for the council's formal approval and receipt of those policies and procedures. And with that, I stand for any questions. Thank you.
Do we have anybody here from the mayor's office?
Madam Chair, members of the board, my name is Samantha Holtz. I'm actually a deputy city attorney, so I'm here kind of for both the mayor's office and the city attorney's office tonight. Mr. Aguilar is actually out of town tonight. There isn't anything specifically to report, but the mayor's office did want to keep open a line of communication with you, and if you had any questions or messages to send back to the mayor's office or the city attorney, I'm here and open to send any messages that you have. Thank you so much.
Thank you. CPCs.
Chair Galloway, board members, Chris Sylvan, Community Outreach Manager with the Albuquerque Police Department. Welcome to the new board members, Eric and Tara. Good luck to you. I'm going to start out with what I always start out with, talking about the Southwest CPC. Southwest CPC has shown a lot of improvement. They've added 2 new board members, council members this month. The chair resigned, but, they're looking up. Attendance is getting better and better. They are now meeting the first Wednesday of each month at the Pat Baca Library. So my other ask when I come up here is that now our Valley is struggling. We're down to 3 council members. So if you know anybody who wants to join the Valley CPC and lives in the boundaries of East I-25, North Montano, and west is the river and the southern border, I don't remember, but yeah, we need help with the Valley now. So for that, I stand for questions.
Thanks for coming, Chris. I guess it's not a question, more of a comment, and perhaps something we can work with City Council on. But when I was on Northeast, and I think I even mentioned this during the interviewing process, one of the things that I think would be really helpful that the POB can do to help CPCs is somehow get information to prospective applicants for the board to funnel them into CPC. So I think at one time I heard we had 70-some applicants in the pool. Obviously now we're down to one seat. So not all of those folks are going to be seated, but they're interested in serving, and there's potentially seats available on the CPCs. So I don't know how the board can help facilitate that, but I think that's a really great pool of folks that are interested in serving, and potentially a good candidate pool. So.
Chair Galloway, Board Member Olivas. Yes, I've been working with council staff, specifically Mr. Moya, to address that, and we're letting the council send out what we would call a letter welcoming, asking them to join the CPC while they're waiting to be seated potentially on the POB.
Love that. That's wonderful. Thank you, Eric. And congratulations are in order to you. You have, you competed in the Senior Olympics, I understand, and medaled?
4th place, but you know.
I think that's awesome. Congratulations.
Thank you, I appreciate
I
that.
can't believe you qualified as a senator.
Same. It was a shock when it scrolled across my Facebook feed.
I'm what they call a young senior, the baby seniors. I'm not one of the older people, but you know, that was a very inspiring event. The city hosted a great games, and everybody I talked to from around the country was very excited about being here, and we showed what Albuquerque can do, and I was inspired by watching 103-year-old people compete in things, and watching my 94-year-old neighbor play shuffleboard, of all things. So,
Wonderful.
but thank you.
Thank you for representing, and congratulations.
Thank you.
APOA, do we have anybody here for that?
Is he in the back? Oh.
Good evening, Chair Callaway. John D'Amato on behalf of the APOA. Nothing really to report except that which you already are aware of. I stand for questions.
I don't see any questions, but
Thank
thank
you.
you for coming. It's nice to have a representative join us.
Thank you.
Thank you. And Director Harness.
Chair Galloway, Honorable Board, welcome to Board Members Armijo Pruitt and Olivas. Thank you. IMR 10 reporting period ends July 31st, so I will need your ride-along information. Dan Giaquinto and I will be discussing cases for review for that 6-month period on Monday. And earlier this week, I submitted our paragraph 196 compliance letter to the monitor, and that is the annual review of the retaliation policy for APD. You've received the 2018 semi-annual reports, and I believe they've also been uploaded to SharePoint. So I would like board feedback no later than the 31st of July, so that we can prepare to have those ready for the next board meeting in August for a vote, so that they can go to City Council. The investigator and the data analyst job descriptions are drafted, and they are at HR. I'm waiting for them to be posted on the City Jobs website. Stakeholder compliance update. That email went out to board members. That is APD's update of compliance, which happens about every 6 weeks. Either August 6th at 1 p.m. or August 7th at 10 a.m. I have heard from members Vandeventer, St. John, and Armijo Pruitt. I would like to hear from the rest of the board as to their availability. The other party, AMRAC, is available both of those days.
What date is that again? August?
August 6th at 1 p.m. or August 7th at 10 a.m. Chief Guyer responded to the board's letter regarding progress on the overtime policy. That email, his response email went out to the board members. He could not, at this point, commit to the August 5th meeting. He had to check his schedule. And if he had a conflict, he would get back to the board to try to work out a mutually agreeable date for his appearance to update the overtime policy rewrites. The Office of Policy Analysis only met once this month, and that was today. Today there was a review of 2-9, use of computer systems, and 4-7, police and community together, which is a policy that is being retracted. PPRB did not meet this month, or this week either, actually. I will be doing a presentation to the 121st Cadet class on Monday, the 15th of July. This class will graduate and hit the streets on the 22nd of July. I will be presenting at a workshop during the NACOL conference on the 23rd of September. That workshop is titled Driving Change Forward, Vehicles for Reform in a Time of Declining Checks and Balances. The Force Review Board training is August 1st and 2nd. That's a compelled training that I must attend to be in my ex officio role on the Force Review Board. I will be presenting the quarterly report to City Council on August 5th. That's the oral report given to City Council. And last is training. NACOL is September 22nd through the 26th. We need to know as soon as possible who plans to attend NACOL. If you don't plan to attend NACOL, there is an option September 30th through October 3rd, a training session through the Americans for Effective Law Enforcement. And that workshop or that training session and conference is titled Discipline and Internal Investigations. Other than that, I stand for questions.
Where is that training? Is that here?
Chair Galloway, the AELE training is in Las Vegas.
Is NACO in Las Vegas?
Chair Galloway, Member Waits, NACOL is in Detroit this year.
Director Harness, what did you say the NACOL dates were again?
Chair Galloway, Member Vandeventer, those dates are September 22nd through the 26th.
Thank you.
And did you say September 28th through the 3rd of October?
September 30th through the
30th, okay.
Chair Galloway, Member Fine is correct. September 30th through October 3rd.
Wonderful. Have you had an opportunity to go around to any of the CPCs to present? I know we had talked about that at outreach, but I've been out of the loop for outreach for a couple months, it feels like.
Chair Galloway, not a formal presentation. I believe we may be on schedule for next month at Foothills.
Okay. Okay. Any other questions?
Excuse me,
Yes.
Director Harris, I have a question. Could you reiterate, so far a second ride-along, it has to be completed by July the 21st? Is that the date?
31st.
The 31st?
Chair Galloway, Member St. John, July 31st.
July the 31st.
The
Okay.
evaluation
Does it
period.
have to be completed or booked? Does it have to be completed or booked?
It should be completed because this is the 6-month evaluation period for IMR 10.
Okay, thank you, sir.
Any other questions? Thank you, Director Harness. Reports from subcommittees. Member Fine.
The outreach committee met. We went over the materials that are now almost ready to be reordered and the process by which we will do that. We are setting about to finalize the reports that the staff have put together for the purpose of us getting them printed and being able to walk them around town and do some visits with members of the community and talk about what has been achieved by the CPOA and its board. So that's the next piece. We discussed some media interviews and conversations, and that's the extent of what we completed. Our next meeting will be at is it the last week of August? I think it's the last.
The
in
27th.
27th of August in the, I'm sorry? July 27th. I mean, is it July? Yeah, July 27th. I'm already in August because I'm talking about that training and stuff. Yes, July 27th at the Plaza del Sol building. At what time? 1 o'clock? 1 o'clock.
Saturday?
July, she's checking.
July the 23rd,
July the 23rd.
22nd?
23rd. Can we just put those on here, on the agenda, when they are again? Because we know when they're going to be. That would be helpful.
Okay. And policy and procedure, Ms. Vandeventer.
Okay, so, let's see, since the last meeting, as discussed, Ms. Gooch and I finalized our internal rules and procedures and forwarded them to the city council. Our communication, as Director Harness mentioned, to Chief Geyer regarding rectifying the overtime issues identified by Mr. Scotchtiple's investigation went out. We have a response from him, so we're just looking to firm up dates and times regarding when he will be reporting back. There has been only one OPA meeting in the last month. It was held today. There's nothing of immediate concern to the board from the policies discussed at that OPA meeting. There is no PPRB meeting in this past month, so we have no comment due. So that's most of everything. The substantive thing for the board at this time is a discussion of the APOA's objection to policy 2-57, and that's the policy that concerns investigating use of force incidents. And so essentially the history of that policy is it worked its way through the 352 process. The APOA now objects to 257 as it is written, as it was forwarded to the monitor, on the grounds that it did not, they're unsatisfied in how much that policy incorporates Graham as the reasonable standard, which was basically the main bone of contention for all of the use of force policies. It just continues to come up. But they have objected in a pleading to the court. And so now the decision and discussion for us today is to determine whether or not we would like to respond in some way. We cannot file our own pleading because we're not a party to the lawsuit. But I understand that in the past, the practice has allowed parties, amici, stakeholders, to respond via attachment to the DOJ's response. And so if we would like to do so, if we would like to respond to the APOA's Graham objection, we can do that. And so I would support doing so. I don't know what other board members might think.
Thank you for bringing this to us. I think that's really an important conversation, one that we've spent a lot of time on in this board. Clearly, we have expressed our concerns about the inclusion of Graham and the actual conflict that it presents with the new use of force attitude and principles on which it's based, believing as a group that we really felt like that adding more Graham into it or adding some aspects of Graham would actually create a conflict for officers in the field. So we've been really clear as a board about that. I think it's a really good idea for us to encapsulate that. I think the policy committee could do that, since, you know, you were all part of the board at the time we had those conversations. So for myself, I think that that's a really good suggestion, and we should go ahead with it.
Dr. Cass?
Yes, I would like to hear from Mr. D'Amato regarding this, just to clarify what the situation is and what APOA's objection is, so that we have some place to start from.
John D'Amato, once again, Chairman Callaway, how are you?
Hi.
John D'Amato, on behalf of the APOA. So I can't comment on behalf of the APOA with respect to their position on whether this board should or should not respond to our objections. Stepping out of my role as an APOA attorney, I would invite any objection by any interested party or a community member. There's one sentence in 257 that we object to. So when you analyze the SOPs as a suite, focusing on that one sentence, and then fashion a response that addresses the APOA's concern. It's a very narrow concern. So there's more, obviously, to this story that meets the eye. The pleading, I think, is well drafted, better drafted, I must admit, than my letter to the board most recently. However, we invite spirited debate on something as vital as a use of force issue for the city. You know, there are many, many positive things coming out of the reports from APD tonight with the various area commands. That's pretty heartening. We talked about this many times. We have the ultimate goal. Similarly, how we get there is the debate.
As a matter of clarity, I'd just like to ask, is it fair to say that this deals with the reporting requirement or the review?
Oh, the second part of our objection is because of the way the sentence is structured and the scope of authority that sentence casts, those who are investigating and reporting up the chain are targets for, hey, you didn't ask this. Go back and ask this. Go back and find that. That sentence plants such subjectivity, not only into the use of force, but the investigation of force. And once, yes, ma'am. Yes, sir.
For the purposes of clarity, because we're not the only ones listening to this conversation and needing to understand it, it would be helpful to know what sentence you're talking about.
I do not have that file before me.
Okay.
The sentence is specifically, if I can summarize, and I'll check to the city attorneys, half of the definition of the test for qualified immunity in a civil setting. The second half is what is clearly known or what is clearly established. If that second part was put into the sentence, then, and we can argue this in court, but in summary, the import of the way the sentences are drafted, both with respect to the use of force as well as the investigation of force. Thank you. Counsel for Executive Director has just given me the pleading. So, for the record, I'm looking at document 447. The third paragraph of the Standard Operating Procedure 2-57-2 ends with the sentence, supervisors and FIS detectives shall consider the facts that a reasonable officer on the scene would have known at the time the officer used force. If it added facts that were clearly established, you are completing, in my assessment, the test for qualified immunity. Leaving that second part out in a non-qualified immunity setting injects subjectivity to the point where probably if this were to pass as written, the future will dictate what I'm portending. not good news. So when you respond, of course, respond to the second section because the supervisors and investigators are going to get caught up in this and subject to discipline. That's the hurt. So, yes, I mean, personally, as an attorney, as one who debates, we invite comment. We invite. Thank you. Other questions?
No, thank you. I appreciate your coming down and clarifying this.
Yeah, it's my honor. Thank you.
But it's essentially about only deals with the very last policy. The other use of force, the other uses of Graham language within the policies.
Dr. Cass, may I? Yes, because from the very first policy addressing the use of force in the city of Albuquerque up until 257 is consistent with our understanding of the application of Graham versus Connor. It's recognized in the policies that the city has a policy more stringent than Graham versus Connor. And that's clear throughout the policy. That sentence kind of throws a grenade in the whole suite. If you look at that sentence starting from the very first part of the policy. So that's all we're saying.
So your contention is that how it's stated in 257
Well,
screws
as we
up what's in the other policies. It brings into question,
It undermines their effectiveness.
undermines, great word. Okay, so that's your contention?
Yes.
Okay.
Thank you. Thank you, Chair.
Does
Members of the board.
I'm sorry, no, I'm sorry, I have a
Go
question.
ahead.
Does the APOA have a recommendation on language?
Well, you mean in the
Eliminate the
filing?
sentence.
It'll just eliminate the
That's
sentence?
our first position because that then leaves the rest of the suite pretty objectively investigatable, if you will, and trainable. How do you train that sentence? Let me read it again. Supervisors and FIS detectives shall consider the facts that a reasonable officer on the scene would have known at the time the officer used force. Consider that tonight and just bubble that around in your head and see how subjective that is. Because what you believe he would have known, I not necessarily do believe that. How would he have known that? So,
Let's go back to Chelsea.
Thank you.
thank you.
Yeah, so that is the kind of debate that grows out of Graham and to what extent it is or is not incorporated in the policy. So I think that we've held a very consistent position and that we can expect everyone else to reply and that we should join in replying. I don't think, it doesn't really make sense for us to just suddenly stop.
Yeah.
We're kind of midstream. The policy development continues to be ongoing. A reply is what's called for at this time. So I would move that we figure out some way to reply.
Chantal.
Yeah, no, do you have any recommendations as to how that should be drafted?
I think that would be the next thing for us to figure out. I mean, I could see Director Harness doing it. He can't see that. Or our attorney doing it. It will be a legal reply, so it shouldn't just be a letter coming from us, I don't think. But we have a clear record. All of the motions we've made are available in, video form. Yes.
If the presentation that Mr. D'Amato offered about just removing that sentence, he does not believe that would be a negative impact in terms of Graham versus Connor and the other standards that would apply. He thinks removing that's not a big deal. I assume you disagree. The policy committee disagrees.
I believe the policy should remain as currently drafted.
Okay. And so your policy committee discussed this and decided that together?
What we decided was that it was appropriate for discussion amongst the board. We wanted to get the issue before the board right away because, of pleading deadlines, et cetera. We're expecting, if I understand correctly, we're expecting the clock to start over because we're anticipating, I believe it's the APOA to file another notice of errata, which will have the effect of starting the clock over, giving everyone a little bit more time to comprise their responses. But nevertheless, time is of the essence, and so we determined that we should bring it directly to the board. We don't really have a recommendation. Our subcommittee is currently comprised of board member Dr. Cass and board member Chair Galloway and myself. My summary of that conversation would be that Chair Galloway and I both thought a response was appropriate, but that we thought the board should make that decision.
Okay, agreed. So then my question is, if the sentence were removed, just so we're clear on what you and Chantel would have us think about, what would be the impact of removing that sentence in your view? And then let's hear from Dr. Cass.
Well, okay. I appreciate your tough questions. I'm not, I read that response several days ago. But my take on the pleading as a whole was that that more or less, if you alter that language, then what is going to happen is that the use of force policy will impose a more stringent standard than the one found in Graham versus Connor. Yet the investigatory SOP will have a use of force investigated at the Graham versus Connor standard. So it would kind of erode at the imposition of a higher standard, which would kind of really make the rest of the work sort of null and void, or?
That's a very good answer. I really
Okay.
appreciate that. That's really helps.
Sure.
Chantel, what were your thoughts?
I'm going to let Dr. Cass, because
Yes,
He had a
I think
dissenting-
we're treading on very dangerous ground here, and I think to suggest that we as a board are making a legal response to this is not within the purview of what I think the board is supposed to be doing. I think the board makes recommendations, and we made recommendations as this process was unfolding for several months. And at this point, there's one last, and we have a different position in this than APOA has, and I think we have to be careful about how we respond to this because we're still in the business of making recommendations. So to suggest that we have an attorney draft this and that this be some sort of legal document, I think is out of the scope of this board's mission. So if we want to comment on this, I think we can make a comment, but I think we ought to have some thought about what those comments are going to be before we, I think this is a good discussion to start it, but I think it needs to be considered, and the place to consider that would be the Policy and Procedures Subcommittee. So I don't see that there's particular urgency in getting this out, other than it be soon, but at our next meeting. But I think it ought to come back to the Policy Subcommittee to draft some kind of a response if there is one to be drafted. But I think we're taking on a big issue, and I don't think we're prepared as a board to do that. So.
May I ask you a question? So if, given what Chelsea has said, what she thinks the removing of that sentence, as Mr. D'Amato has said, would do you disagree with what she has to say, regardless of what form we use to answer and give feedback? Do you agree in substance or disagree with her?
I don't think we can, I can't make a prediction as to what the effect is, and I don't think anyone on the board can either. So, I mean, what's being created is a policy that'll have to be tested as it, as it's trained and released. And so when, you know, it's a living sort of document in that it will change with time as we learn more about it. And I think that you go forward with the best policy you can, and then as necessary, you modify it to improve it.
Should I take that to mean that you think that that sentence should stay in for now?
I don't have a position on whether the sentence should stay in or not. I think that it's beyond our ability to determine, I think, at this point, because I think the process was a much longer ongoing process that involved a very complicated situation with a half a dozen different policies. And I think to now go and pick on one sentence, APOA can do that, and they've done that, and that's their prerogative. But for us to weigh in on the same level and say, well, we're going to, challenge the idea that the sentence should or shouldn't be in there, I don't believe that's within our scope.
And why I don't understand why you don't think so, since we are responsible for policy. I don't understand why this policy is something, I just need to understand.
Well, we're not responsible for policy, we're responsible to make recommendations.
Well, why would we make a
And
recommendation?
we have made recommendations, and this essentially is another recommendation on the part of APOA that's different. I mean, there's lots of players in this
Then why should we not be
this
counted?
process.
Well, I think that, to your point, Dr. Cass, we were among a group of parties and interested individuals who worked on this policy, and the policy as it is with that sentence in there is what was approved through the process. And it's not that we're challenging what was approved through the process, it's that we're responding to a challenge of what was approved through the process as a member of the team that drafted this, that compiled this, created this
Well,
document.
maybe that's a
So
way forward.
I think that there's two separate issues. The first being, do we want to respond? The second being, how do we want to respond if we do want to respond? Leonard?
Well, first of all, I don't think we should take on one sentence. I think we've looked at the overall policy. What I would suggest, and maybe, I could be wrong, as a board, take a look at it again, and any changes that we recommend as individuals, submit to the subcommittee, and not just that one sentence. I don't think that one sentence is what we want to take on.
I see your point, yeah. I think that what Dr. Cass is, if I heard you right, just tell me if I didn't, but if I heard you right, you're saying we already did all this stuff, let's let it go forward. So what if our letter didn't talk about that sentence, but said, we think we should go ahead with what is proposed, and we're in support of that, and come back to it at another point? In other words, not deal with the sentence, but deal with the whole process. Does that work for you?
No, I accept that, but I think that's what is the normal course of events, this just happens to be a situation that was raised, an issue that's raised by APOA. I don't think we have to respond to every issue that APOA raises. And, they have a different position in this, and I respect their position. So if they raise this issue, then let the next level of expertise in this, which is the monitor and the court, decide how they're going to handle this.
Do we have any other comments, any other thoughts from any other board members? Because I would like to move the first question forward. No? Okay, so I'm going to make a motion that we go on ahead and draft a response. We can discuss what that would look like afterwards. But I'm going to go on ahead and make that motion so we can decide if we're going to take this conversation
Chair
further.
Galloway, I already did make the motion.
Oh,
so
sorry, then
it's
I'll
okay,
second it.
Okay, thank you.
All in favor?
And the motion is to what?
Whether or not we should respond.
Okay.
I seconded it. So,
All the,
all in favor? Aye.
aye.
Any opposed? Okay, great. So we're going to respond. How we do that is now what's up on the table. So I'm in agreement with Dr. Cass. I would like to look at this, and maybe, I think it was Dr. Cass, it may have been Leonard. I'd like to look at this in context and have a respond to Chelsea by date. Yeah,
Their committee.
Their committee.
so is that acceptable? Chelsea, when would you like to have responses from the board members?
Let me make one inquiry. Director Harness, do you happen to know what deadlines we anticipate worrying about? Or Mr. D'Amato, would you happen to know?
Chair Galloway and Member Van Deventer, I am currently unaware of the pleading response times.
It's coming down.
Chairman Galloway, members of the board, thank you. John D'Amato with APOA once again. I believe the earliest will be July 15th. A response is due from the parties at their discretion.
So that's just in a few days.
Next week, next.
Yes. Mr. D'Amato, are you planning on filing a notice of errata?
What is
I
that?
think I filed the second one, and that should be the last one.
Okay, and that is the one that's connected to this response deadline?
I believe so.
What is it?
Oh, it's just like, you know, when they said I don't recall what error they made, but they just filed a notice with the court that there was an error in their former pleading. They correct it by filing that notice of errata, and then it changes the time in which people have to respond. The clock starts over. But I think that we thought there was going to be another one which was going to buy us some more time, but that might not be the case.
It was my understanding, and I pled the last errata with the correct substance and form of the SOP in question, the SOP. So what that resulted in was the renumbering of the exhibits.
Okay.
So if you don't have the most recent, please contact my office or email me, and I'll get that over to you.
Okay. We might be able to ask for additional time in which to respond.
Can we do that as not being a party to the?
I think we would have to consult with the DOJ since they're going to be the responding party.
I think that if we don't deal with the sentence, but instead say, we support 257 as written
We
at this
can
time.
reply
We can
immediately.
reply it and say that.
I would agree with that.
And then everybody's got what they want, right?
Right.
Ms. Gooch appears to have a comment.
Please.
Chair Galloway, Board Member Van Deventer, and Fine. Correct. If that is what the board votes to do, as long as that recommendation letter is presented to a party for filing before the hearing is set on the pleading, your voice should presumably be heard. But if July 15th is the deadline, the board would be at the behest of one of the parties to the case to seek an extension if you wanted to have a substantive response filed.
Why couldn't we make the 15th deadline if we agree to just do this? We like 257 as it is, period. What if that was our response?
Chair Galloway and Vice Chair Fine, yes, you could make that deadline. It would require, I believe the prior practice is a letter from the board that is submitted to the city, APOA, and DOJ, and the Department of Justice has traditionally filed those letters with the court so that they come before the court in the record. But I would have to communicate with those attorneys just to verify that that would be the process in this instance.
Okay. Yep. I mean, I could just write something that simple and forward it to Chair Galloway, and Chair Galloway could forward it to Ed or Tina, and they could forward it to Liz. And then Liz could forward it to the judge. If that's what you guys want me to do. I mean,
All right, so let's.
it's a path forward at
Yes.
least.
I wanted to say something on this briefly. I really like the wording that Dr. Cass used on this, basically saying that we don't necessarily support or oppose this change, but we want to see the process play out as a living document and let this evolve. I just kind of prefer that verbiage versus saying that we specifically support this policy, when I don't really feel like there's been a cogent argument made for or against this current wording by anybody here. So I feel like if we insert ourselves here and say that we fully support it as is, I'm not sure I've really heard that argument fleshed out here,
So I
other
think-
than that we want to see things play out naturally.
I think that the idea behind supporting the policy as is that we have already done all of that work and been to all of those meetings and had all of those discussions, and this was the end product that we, all agreed to move forward. And so I think that that's the idea behind it, and not weighing in on that specific sentence in support or not supporting of it. And so I would hate to see us kind of backpedal on all of the work that we've done. And
It was
say
a
that
very
now
strident conversation
Yeah.
in which we were very strong about not inserting Graham versus Connor as a way to supersede the existing policy.
Yeah.
And that was a reform policy. And so we were very much in favor as a group of that. And so to say we're not in favor or for or against this, for some of us, we are against that, okay? I'm just trying to avoid the some of us to all of us and say, we worked on this already, we already agreed to it, we still agree to it, okay? And we'll see how it goes.
Yeah, I think that if we did anything other than that, it would essentially be the same thing that the APOA is. They have a stronger footing than we do, but all of a sudden we're changing gears. And I don't think that's the best course of action.
Yeah, I think if we went with that language, it would be a complete change in position. And it would, we would really have to have an entirely different discussion, and we would have to rewind a few steps and take a new vote on 257 as a whole, because we would be, if we suddenly said, we actually don't have any feelings about that, that would be completely inconsistent with everything we've done thus far. So.
Director Harness, do you have anything to add to this conversation? I saw the meeting of the minds.
Yes, Chair Galloway. The language that is being opposed by the APOA is language that was drafted by the city and had the approval of all the parties. The Department of Justice and the city will be vigorously opposing the objection of the APOA. As it relates to your ability to draft a letter and get it submitted through the DOJ, because this is a motion and not a status conference or a matter of concern for you as a stakeholder, that letter would have to be vetted and have to go through the process of getting approved by the U.S. Attorney. Given the shortness of time, that process would not happen in this case. So I think that while you can vote and express your support for the language remaining, if the board choose to take that position, that would be the extent of how you could contribute at this point in time.
And I think that is where we're at, right?
Well, we had talked about doing it
Drafting.
as a letter. So we had a motion to say we would send a response, but we're not going to do that according to what he's telling us.
I thought, I must have misunderstood. I thought that would be, I thought Director Harness was saying that's the extent of what we could reply with
No, we
in
can
a
make a
letter.
motion here, but he's saying the letter would have to be vetted. Right?
Chair Galloway, Vice Chair Fine, Member Vandeventer, that's correct. It would have to work its way through the Department of Justice chain of command for it to be presented as a part of a motion. However, if the board does take a position and want to express its position, the opportunity would present itself at the August 20th status conference.
And we could also make a motion right here tonight saying that we're supportive of the policy as it's written.
Chair Galloway, Vice Chair Fine, yes, you could certainly make that motion, and that would be your position.
Okay, so
So we'd have
the
to
res-
rescind the first motion.
the response isn't going to be in letter format, but
yeah.
we'll do it here. So I
Yeah.
think we said that we were going to respond. I don't know that we need to rescind that. So now that we have all of that information, I guess the motion would then be to affirm from our position here the 257 as written.
Is that
I
your
would
motion?
second that
would-
motion.
Yeah. All in favor?
Aye.
Aye.
Any opposed? Okay.
One quick question, follow-up question. The August 20th status conference would be another opportunity for us to affirm that position. Should we send somebody from the board to discuss that at the status conference? Or, well, I mean, Director Harness already goes. He can relay the position of the board.
That would be the simplest, I would think.
Chair Galloway and Member Vandeventer, the status conference and the content of your positions and what you present to the court is a discussion item later in the agenda.
Okay. I rescind my follow-up question since we're rescinding this evening.
Okay. Any other business for policy and procedure?
Oh, yes, that's what we're doing. No, that concludes our business. Our next meeting will be held on August 1st at 12:30 in the basement of the Plaza del Sol.
Okay. Member St. John for case review.
Okay, our last meeting was on June the 25th, 2019, at 11:30 a.m. At this meeting, there was no discussion of cases or votes taken on any issues. The purpose of this meeting was to discuss two items. The first one was the ordinance. The second was recommendation to the full board on how to proceed with the cases until City Council takes final actions on the ordinance. In regards to the ordinance, the City Council has amended it for clarification, and this proposed ordinance will go before the City Council on August the 5th, 2019. Also, Mrs. Gooch, the Board Attorney, will be advising us, and we can schedule our next case review meeting. In regards to the cases, the Case Review Committee, our plan is to just extend the next meeting, and if necessary, we will add another meeting. And Director Harness has posted these pending cases that need review on SharePoint, so we all have the opportunity to review them. It's not like we're not doing anything. The Case Review Committee, we're still working our cases and we're reviewing them. We're just not discussing or voting on them. Do you have any questions?
So it's just a point of clarification, the second meeting you talked about, it because there's a number of cases backed up, it may take more than one meeting for us
Right,
to catch up.
yes,
And so the second meeting would be for that purpose.
Right, that's correct.
So we won't be discussing these cases tonight?
No.
Okay.
I think Mr. Harness may have some cases he needs to discuss. I think that's what we heard. Is that right?
I don't know, I haven't heard anything.
Did you?
Chair Galloway, Vice Chair Fine, Member Waits. It would be my preference that all of these cases that are on the agenda, that the board accept the recommendations of the agency. Two of these cases, the sustained cases, 048-19 and 072-19 have already been submitted to the chain for review based upon the time constraints because there were disciplinary recommendations. I think that we, the agency and I, have held the position that these cases should be reviewed by the full board, and if there were questions about them, then they could be discussed here at the meeting before a vote on the recommendation and the recommended findings. I think it's fundamentally unfair to all the parties at this point for these cases to continue to linger. We have complainants calling, what's going on with my case? We have officers now who are starting the bid process who may have a finding that is finished but has not been voted on by the board and could impair their ability to bid for certain positions. Along with that, there will be no way that we can meet our timelines for investigations in IMR 10 because the fact that the board has not reviewed these cases means that these cases are not fully closed. Therefore, we are going to be out of time for all of these cases, and that affects our investigative timelines as well. As discussed with Dan Giaquinto, it's not necessary to do a deep dive on all of these cases. A deep dive could be done on cases where board members have questions, and certainly those questions could be presented here at a full board meeting for the board to review these cases. So I just reiterate that it's the agency's position that the board should pass these cases as are recommended and as they are on the agenda.
I strenuously object to that.
I would like to say something first. I understand your concern, but I also the board members should have had notice of what you were going to say tonight, because none of them has probably reviewed them in SharePoint.
Well, it doesn't matter. We are not the cause of this delay, okay? It was not our doing that made this delay happen. So if you have cases that are with discipline and you want to bring them, rock on, do it. But the rest of the process is a process that we will go through as we have. But to hold us accountable for that, when we're not the ones who did it, the city made a change in the ordinance that affected whether or not the case review could meet. We will make up that time, and to behave like this is not okay with me. It's not okay that we bypass the process of the board review, nor is it okay that we bypass policy or outreach or personnel or any of it, okay? So I object to you saying this as though it were the fault of the board. It is not. And we will catch up as soon as we get, it just lights a fire, the same fire that you have, we have, for this process to be reconstituted as it was before.
I think, though, the impact as far as the reporting goes with the monitor, regardless, it's as it was with having vacancies on the board, even though it wasn't of our doing, we were still dinged for it because we didn't have a full complement
Well,
of the
then we may have
board.
to be dinged.
And so that's an option. I will tell you all that I have not reviewed these cases. I have not done it. I am not opposed to having a discussion about scheduling a meeting specifically to do these in a week or however long. I will tell you the piece that concerns me is that there were 2 cases that have already gone through the process without the board moving it that way.
We have had that occur.
Concerns me.
We have had that occur before because of the discipline rules. Remember, for those of you who may or may not know, the timelines to this are tied to the union contract, period, okay? We have to reply in that because of what's in the contract, which I'm not saying yay or nay about. I'm just saying that's a fact of life. So if they want to get in discipline recommendations, we have done that before. We have brought cases, and he's described what's going on and why he's doing it. I would ask, were these cases not ready last month? And if they weren't, and there was a timeline, what was the timeline? But the question is whether or not he can do that. He can. He has to sometimes. And that doesn't mean that we don't get to hear about it afterwards. We should be able to hear about it because it was passed on in order to make the discipline recommendation power.
I want to jump in here real quickly.
I'm sorry.
I think it's.
I'm sorry. Give me just a second. Ms. Van Deventer had asked first, and then we'll come back to you, okay?
Director Harness, I just wish that you had raised these concerns at the case review subcommittee meeting we just had, because the entire reason why we met was to figure out if we were what the case review's recommendation was going to be for handling cases in this interim period while we're waiting for the ordinance to change. I'm neutral. I would be fine reviewing the cases here. I would be fine reviewing the cases at a special meeting. I'm fine holding off until our anticipated August meeting where the ordinance fix should be in place. But you didn't let us know any of these things that you seem, sort of upset about. This was not communicated until this moment. And we could have had a discussion, and that could have impacted how we handled this. So I wish that you had raised the concerns more timely so that we could have considered those concerns as we prepared this particular recommendation for the board.
Chair Galloway, Member Vandeventer, I raised these concerns last month at the board meeting when the board decided to table the cases previously. This is not a new position. I'm simply reiterating the position that we've held. I'm letting you know that in accordance with the ordinance, I am empowered to move those 2 cases forward, which I did. And I'm simply reiterating our position again, as these cases are on the agenda for this evening.
We could have had a more robust discussion about it, though, because at that's what that subcommittee meeting was for, and we didn't discuss your concerns because you didn't raise them at the meeting that was intended to be a discussion of this particular thing. And I wish you would have, because we could have maybe come to an entirely different conclusion where we're not having this issue right now.
Well, and there's nothing that says that when, any cases that he put forward, in order, what we've done in the past is he's explained those cases here at the board meeting and said I had to put these forward because it was a discipline thing tied to it. So you can do that now.
We can do that in just a moment. Mr. Olivas?
So I want to say I take a totally divergent view here. I completely support the agency's position on this. I've spent a good deal of time as a new member reading the ordinance, and it's the responsibility of this full board to review cases. I think that we're abdicating our oversight authority to the agency because we're not seeing these cases in a timely manner. Because now these recommendations are being made to the chief without our input, without our review. So we're actually losing authority here. We're ceding authority, and we're reducing transparency and oversight of the department here because we're delaying cases for a matter that is arguably out of our control. But the full board is still able to hear cases and vote on cases, and I wasn't aware that that wasn't always the procedure here, that we were abdicating that to a smaller
No, you misunderstand.
committee.
The committee it's not an abdication. The committee reviews, like most committees review things in real drill down fashion. And we bring the concerns we share, one of us or all of us, and bring them out and say, here's what we're concerned about. Here's what we discussed. We go through the drill down and we make recommendations to the board. We don't vote on whether they go through or not.
Well, no, I understand that, and I fully support that process, but I also think we need to look at the bigger picture here, which is that ultimately it's doing a disservice to the complainants, to the department, to the agency, and to ourselves to not act on these matters in a timely fashion. Because I was here in June when these cases were deferred, not on the board, but I was here, and now they're being deferred again, so we're creating an even larger backlog.
Why
and
that
in
is?
theory, in August, this will pass council, but
Do you know why they're deferred? Because the city council created a line in the ordinance that said the case review committee cannot exist because every case should come to the board without the process. And that is what we objected to. So the city has now acquiesced to that or not, or said that wasn't our original intention. And now we're changing that back to what it was before. That's the process we're in. Our attorney said that we were in danger of being sued, brought to court because we were hearing cases when the ordinance wasn't resolved.
And that was
That's
the reason for the suspension.
no, I understand that and support that, but what I'm saying is that we still, as a board, the change in the ordinance didn't change our ability to act on cases
That's not,
as a board.
that's true. Well, it sort of is true. Valerie?
But I'd like to call something to your attention. I mean, there isn't that big of a backlog. We can do it in one meeting when we get the okay from our attorney. As of July the 9th, 2019, there was 36 administratively closed cases, 1 appeal, 1 exonerated, 1 sustained, and 1 unfounded. And, he's adamant, and we're reviewing them, but there isn't like hundreds. We can do this in one meeting. And yes, it's inconvenient, but we're at, and we're ready to move forward.
And we didn't cause this to
And we didn't
occur.
cause this problem.
Okay, so Director Harness, is there a way to easily kind of parse out the cases that are administratively closed because they're not in our jurisdiction? Because there was
By
no...
the time you do that, you're going to be done with it anyway.
That's why I asked easily. I don't know, I'm not on case review, so I don't know.
Could I ask you exactly where we are on the agenda? It seems
We're
Case review.
We're under
I was
the
just
committee
gonna-
meeting of case review, so we're not
And-
going to do that yet. I'm just asking the question if it can be done.
Well, what I'd like to do is close out this case review report so that we can move on to other business.
I would like an answer to my question first, and then I'm happy to do so. Director Harness?
Chair Galloway, quite frankly, no. I mean, these administratively closed cases may have a page or two of dialogue within the findings letter. So, quite frankly, no.
Okay.
Can we ask Tina? Tina, do you know how long it will be until this issue is resolved with the ordinance?
Chair Galloway, Vice Chair Fine, no. We know that it is on the August 5th City Council agenda, we think. I haven't seen the agenda posted, but it's been represented that that is when the amendment is going to be presented. What City Council will do with it at that meeting is anyone's guess. It could be voted upon, it could be tabled, it could be, I mean, the world is their oyster. That is not a legal term, but I don't know. It could be that we find out August 5th and that those that are in attendance at that meeting from the board will know immediately what the answer is. It could be that it will be another month or two down the line before we find out. And it could very well be that the amendment is not passed. I mean, it could be any number of things that we are waiting until August 5th to find out what the answer is. And hopefully we have an answer that day, but we also could be told to wait a little longer. I don't have a clear answer.
Mr. Moya, do you hear the urgency in this? And the consequences of this?
Madam Chair, Board Member Fine, yes, I do, and I'll relay that back to the sponsoring counselors.
So I'm going to propose that we take the remaining time in this first half of our board meeting and then kind of mull it over as we go on break in just a moment, to think about how we might propose handling these cases in the future to come to a solution that will work for the agency and get us moving forward as best we can until the ordinance is settled.
Again, we're
Okay.
adjusting our behavior because of the lack of behavior on someone else's
Sure.
part.
We just,
Not okay
we
with
just
me.
may need to adjust further. So, okay. Valerie, do you have anything else for your?
No, that was it. Thank you.
Okay. Next is Personnel Subcommittee. We did not actually meet this month. We didn't have enough members in attendance, but we did have Melissa Kuntz from, and I'm going to do this again, I'm terrified I'm going to do this again, City Attorney's Office? Okay. Come and talk with us. We had on the agenda, I think last month, a personnel policy and progressive disciplinary action policy. And we reached out at Tina's recommendation to the city attorney's office to kind of guide us and make sure we weren't reinventing the wheel, which we were in fact doing. So Melissa's going to come and provide to you all the same report she gave to me.
Good evening, Chair Galloway, members of the board. First of all, I have not met all of you. My name is Melissa Kuntz. I am the Managing Assistant City Attorney for the Labor and Employment Law Division of the City Attorney's Office. And me and my division are your attorneys for anything personnel related. Chair Galloway did forward me a copy of the proposed progressive disciplinary policy. And the city, as a matter of practice, already does follow progressive disciplinary standards. And it is also very unusual for someone at the level of the employee that this board supervises, i.e. an executive director, to make the type of transgression that would warrant progressive discipline. And the executive director is also an at-will employee and unclassified. So taking an action like that would unnecessarily bind the board's hands. So we did recommend against adopting a separate policy and just following the city's existent policy, and also reaching out to me anytime there is a question of disciplinary action, and I can provide you with appropriate advice.
I'm Joanne Fine, and I sit on the Personnel Committee, and as part of that work, I talked to Mary Scott, and she was the one who told me that if the contract went through as it did, that would mean we should have our own process, because Mr. Harness would not be held by the same, through the same process, because he's not technically a city employee. He's, that's what she told me, an at-will employee on contract. And so that's where all of this came from. So now that you're saying we should just follow the city things, it's confusing to me.
Chair Galloway, Vice Chair Fine, members of the board, Mr. Harness is a contract at-will employee. The vast majority of city employees are not contract, and even more, or most of them, are classified and they have a property interest in their job. The executive director is bound by the personnel rules and regulations and would be subject to, I think, the same disciplinary process as any other unclassified employee, specifically that he is at will, so the board could, and he does not have a property interest in his position, so the board could issue the discipline it felt appropriate without further process. Does that answer your question?
So the personnel process of the city would not be involved if we had an issue with the employee we supervise. It would be just us.
It's a little bit different. So if you chose a lower level disciplinary action for the executive director, I do not believe you would need further consultation with the city. For instance, you could reprimand the director or issue a suspension. If you wanted to dismiss the executive director, you would need to follow the process laid out in the ordinance and proceed with a recommendation to council.
Okay, so we, again, wouldn't use the personnel system within the city.
It's a unique situation.
Yeah, I know that. That's why we're asking the questions.
But there's no additional process that's needed. For instance, I'm an unclassified employee, so the city attorney at any point could decide to dismiss me or suspend me with no further explanation. And the executive director would be subject to roughly the same process, with the exception that if the board wanted to dismiss him, they would have to send that recommendation to council.
Okay. All right, thank you.
Thank you.
So we have not taken this matter to the Personnel Committee since we didn't meet last month, but I will tell you that I'm inclined to just utilize the resources at our disposal, and that's going to be the recommendation that I make to the committee. Unless we can, I don't even know if we can do this, just kind of agree to dispense with any further discussion of our own policies.
Chair Galloway, I think that with a motion and a seconded vote that is supported by enough of the board, you can do that. I don't know that you need to do anything formal for your subcommittee here at the board meeting this evening.
No. It would be just bypassing the subcommittee. Like if enough of the board was comfortable with utilizing the city attorney's office for these matters,
It's a board vote anyway.
It is. It's just, are we going to do it this month or next month?
I'll make a motion that we do that. Yeah, that's my motion.
All right, I'll second that. All in favor? Aye. Any opposed?
Yeah,
Oops, I'm
before
sorry.
you call for a vote, I'd like a chance for some discussion. First of all,
Sure.
I'd like to hear what exactly the motion is.
The motion would be to table, I'm sorry, it's your motion, but I would assume it's to table any further discussion, or
Right.
not table, but withdraw any further discussion about our own internal personnel policies and procedures with regards to the executive director's position.
What it's actually saying is the work that we did is null and void. You know, we're following the city's policy and procedures.
So is your motion to follow the city's policies and procedures? Is that
It is now. That is my
Friendly
motion.
amendment.
Friendly amendment. And
In a second.
All right.
So, are we comfortable to vote? All in favor?
Aye.
Aye.
Any opposed? Wonderful. Okay, thank you. You're going to stick around and join us in closed session?
Yes.
Okay, I'm going to make a motion that we reorder our agenda to move item, what is that, 14, up right now and utilize this break time in the agenda before we get into discussions further.
Is that a motion?
It's a motion.
Second.
Okay, all in favor? Aye. Okay, and then we need, I'm going to make a motion that we go into closed session.
Aye.
Okay, we got to do a roll call vote, so that's your
Don't we
aye.
have to say the whole thing, though?
Do we need to say, okay. So, a motion to move into closed session to discuss, closed discussion and possible action, RE pending litigation or personnel issues, matters subject to attorney-client privilege pertaining to threatened or pending litigation in which the public body is or may become a participant pursuant to NMSA 1978, Section 1015-1H7, and limited personnel matters pursuant to NMSA 1978, Section 1015-1H2. That's the
Second.
motion, second. Okay, roll call vote?
Aye.
Aye.
Aye. Aye. All right, we are in closed session. Thank you.